that I don't guess either side can argue it. You know what I mean?
Yeah, I wondered if it was a way to save the case because the defendant didn't go to the scene. Well, we're just not going to call that an evidentiary review. But who knows? We'll have the defendant present if we do this.
Yeah. At any rate, I'm starting from the proposition that I don't think it's fair and I don't think it's adjusted, and I think the lighting and the conditions are different. Secondly, I know that we'll all work, but I want to make sure before the jury gets there, if we're going to do it, that the positions are as close to what the positions were when the incident took place. And, you know, some of the original scene photographs from the processing that was done by UPD can give us a good indication and I particularly want to direct the court and the state to pictures 2871, 2872, and
those numbers don't mean as much. That's a different numbering system.
It's the internal numbering system that the CSI, the crime scene folks, used, and that they are, I believe, admitted into evidence, but it's probably easy to look it up that way. I mean, we just want to make sure.
Sure.
There was a measurement from the back of the seat to the front of the back seat, but without the wine bottle, of course. And I guess we need to see make sure that the dimensions are as close to that as possible if we do it. And I would rather do it at the end of the defense's case, because then we've got both the state's experts and the defense experts talking about their evaluation of the interior of the vehicle. And in that regard, they would have the benefit of both expert testimonies, and then they can see the vehicle, and if you're going to allow it, and then be able to use it in the best form possible.
Okay. Anything else on the view? Oh, all right. Mr. Rucker, you said you had another matter you wanted to take up.
Yes, just very quickly. If the court recalls, and by the way, I kind of anticipated the Dow position, and so we had already reached out to crime scene technician Trowett, who has testified previously that he's the person who inserted the Dow, and he's available should that become necessary based on the court's ruling. The other issue I wanted to flag for the court is for Dr. Marty Sellers. The court had indicated that perhaps it might be necessary, I don't know if it still is, to maybe talk to him outside the presence of the jurors. And so I just wanted to raise that to the court's attention because we didn't bring that up first thing this morning.
Okay, I think it is appropriate and just restarting the processes of 2 weeks ago, but one of the concerns that Mr. Samuel had raised in connection with this was, did Dr. Sellers reach out to you all because of having followed this case since it began, meaning, to be clear, since trial began, which is a different posture than what you or Mr. Abate or someone was theorizing. No. He was relaying to the state in his interviews his thoughts and reactions to media coverage back close in time to the incident. So back in 2016, not, oh, I was watching AJC.com in 2018, and so I reached out to you all. I think that needs to be explored because it creates issues, rule of sequestration, etc. And I need to work through what the consequences, if any, ought to be if what played out was Dr. Sellers was watching recent actual coverage of trial as opposed to remembering what he saw or heard, things he saw or heard many months ago. So we should do that. Is Dr. Sellers someone you'd want to call this morning?
Possibly late.
Okay. So we can do that now, or we can do that when we take a morning break. I'll leave that up to you.
How about morning break?
Okay. So we'll take a slightly longer than usual morning break so that you all get a little break as well. In terms of the jury view, I'm inclined to allow it, but I think it makes more sense to have the jury look at it after they've heard from the defense expert as well. So I don't think it would be today. I would ask both sides to confer about whether they want the dowel in there or not, because if you do, you need to agree on who's putting it in there and be comfortable with how it looks once it's in there. I appreciate Mr. Harvey's perspective that perhaps it's a richer experience for jurors if it's in there because it shows trajectory. I disagree with his assessment that it is of no evidentiary value if there's no dowel in there. I think being in there with the door closed provides a perspective that was not achievable despite the many different iterations the state presented during the course of its case in chief. But I do think it makes the most sense for the jurors to have heard from Mr. Gardner as well. It sounds like he will be called during the defense case. So they're not thinking, oh, wait a minute, I was just in the car and I can't. I think that should be at the end, the jury view. So hopefully that doesn't scuttle your plans too much. But let's have the two sides talk about dowelless or doweled view of the vehicle. It's not a final ruling that will do it, but my inclination is that it would be of evidentiary value to the jurors. It's certainly relevant, and it could be set up in a way that closely approximates the conditions. But this will also give, it could be that the defense wants Mr. Gardner to have one last chance to look at how the seats are set up right now. I respect the state's contention that through Mr. Knox, they did their level best to get things into the same position minus the line well. So that's where we are with jury view. Dr. Sellers, we can explore during the morning break. Anything else from the state?
No, I had the truck transported over here this morning, so it is probably downstairs now, if during the break. If you want to maybe have Mr. Gardner come over and perhaps look at it, that would be fine.
Okay, I'll let you guys work through that.
Yeah, I'll just let everybody know.
Okay, I don't know about Mr. Gardner's availability. The exhibits have returned, so I saw them brought in. I don't know where they are now, but they're in the courtroom.
Can I make one more observation before or make one more request? My understanding is that Investigator Griffin will be the state's first witness today.
Okay.
And I anticipate it's going to be another Detective Smith type direct examination. That is, boy, you work for the DA's office, what did you do when you got the case? I don't know whether her course of conduct is an issue in the case. And just to spend the next however long Mr. Rucker takes her through, and then what did you do, and then what did you do, has any evidentiary value since we're not attacking the state's investigation. In fact, as I told you before, the tables are turned, and it's a little bit difficult for me to be on that side of the ball. But that's what I anticipate is going to happen again. And what did you do next, and who did you talk to next? So
you can ask leading questions if you want.
And maybe you can, because I don't know whether there is any there other than what did you do next, and I don't have any real objection to that. If that's the case, though, I don't understand the relevance of that. So I do want to make a motion in limine that if that's the only purpose, if there is some other purpose, chain of custody, I gathered X, Y, or Z, I can understand that.
Okay.
But if it's just, what did you do next, I do have an objection to that.
Okay. Mr. Rucker, Mr. Harvey makes a couple fair points there. Tell me your brief sketch of what you think Investigator Griffin would be talking about. My perspective is, while the jurors have been away for a while, I don't know how uplifting it will be for them if they're going to hear yet another version of there were lots of guns at the ranch, there was a nice apartment that was laid out in a certain way. Man, I suspect they remember those kinds of points. I know that Investigator Griffin touched the case in many, many, many different ways. What are you envisioning, doesn't need to be an exhaustive list, because you may have literally a checklist, but we've got to make sure we lock in this and that. But if it's the whole soup to nuts, I share Mr. Harvey's concern about it either being cumulative or not relevant / they'll stipulate that, in fact, Mr. Hyde handed over firearms to the state, etc. It was a different witness, but the kind of thing we could work through efficiently. What are you envisioning?
And of course, we were sensitive to the fact that, the jurors, I don't think, would be interested in having a recap on every single thing that Investigator Griffin did. But there are just a few particular topic areas that I think Mr. Abadi, who will take Ms. Griffin, will hone in on and specifically identify. It won't be a let's go chronologically, like what did you do on Tuesday and what did you do Wednesday. It's not going to be anything like that at all. And the anticipation was, I'll just share with you, was to kind of culminate with the fact that she has been the person who has kind of maintained the custody and the control of the vehicle since that time. And so she would have laid the foundation for the jury view. And then so
she should still do that if you think that makes, rather than calling her again. I mean, if you lay that foundation now, it's not like they can, well, it's stale now, the objection that was a good chain of custody for Monday the 9th, but not Thursday. Well, right.
And I don't anticipate that kind of objection, anyway, especially with the vehicle.
Right.
Well, I just think, I know it's come up in a couple of jury questions.
Sure.
And so I think that they want to know, like, where's it been, who's had it, and that kind of thing. And so,
well, that's reassuring. It's not going to be, okay, and then on the next day, and I appreciate why that was done by both sides with Detective Smith.
Right.
But he played structurally a different role. By the time Investigator Griffin is the lead, if you will, on it, APD is largely phased out of the investigation.
That's right.
Okay. Well, I think that was a helpful observation from Mr. Harvey, and I'll be keyed into that if things drag on a little bit too much. Anything else from the defense before we get the jurors in here? No. Oh, okay. Then if the jurors are ready, we're ready. Welcome back. It's great to see you all. Some of you got haircuts. I got a little bit of a haircut too. Just want to look fresh for you all. We've got a Masters jersey on, the right color no less, the green. I hope you all enjoyed your time away. We kept you waiting there in the jury room a little bit so you get a little anxious, and absence makes the heart grow fonder. We were working through a couple matters that we needed to so we could proceed efficiently this week. I appreciate you all coming back. You all hopefully got a call on Friday from someone from my team just reminding you that we still had some outstanding business, and we do. I'm sure you remember clearly the state is still presenting its case, and we are going to continue with the state's presentation. Maybe when we break for lunch today, you can give me a sense as to how late you guys want to go each day, but we will keep pressing on. The state did forecast that it envisions resting sometime soon this week, and then we'll need to work through a bunch of legal matters that occur naturally and automatically once the state rests, and we'll figure out what we're going to do after that. But until then, it's the same process. The state will call witnesses, direct exam, the defense will have a chance to conduct cross-examination, and then of course if you all have any questions, you'll write them down, and if they are appropriate questions, they'll be posed to the witness. And if anything comes up where you need a break, just do what you used to do. Wave your hand, get Deputy Murphy's attention. Just you this week? Are we going to have Kane joining us, or what do we know?
Not sure, Judge.
Okay, well, we're happy you're here. All right, and with that, Mr. Abate, if you would call the state's next witness.
Thank you, Judge. The state will call Investigator Johnna Griffin.
Do you swear to affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, you do. Get as close to the mic as you can, Investigator, for the purposes of the court's record. Please stand spell your name.
Yes. Investigator Johnna Griffin, that's Johnnagriffin.
Good morning, Investigator Griffin.
Good morning.
Could
Good morning.
you turn to the jury and introduce yourself and let them know where you are employed?
Yes, I'm employed with the Fulton County District Attorney's Office.
And how long have you worked with the District Attorney's Office?
10 years now.
And tell the jury a little bit about your educational background.
I attended Georgia State University on a volleyball, basketball scholarship, and I received my bachelor's in psychology.
And prior to working at the Fulton County District Attorney's Office, how were you employed?
The Fulton County Police Department.
And how long were you there?
10 years again.
And in those 10 years, where were you assigned?
Yes, I started out as an officer on the streets, and then I was promoted to detective. So I investigated homicides, crimes against women and children, robberies, missing persons, and then I was promoted as sergeant of investigations in that area.
And you said you had been with the District Attorney's Office for 10 years. Where are you currently assigned now?
Yes, now I'm the Deputy Chief of Investigations, and I supervise the Major Case Division. And we handle all the homicides that we receive from the different agencies within Fulton County. We have about 43 investigators, and I have a chief who's above me.
Now, as the Deputy Chief, other than supervision, what are some of your job roles and responsibilities?
I also assist the chief investigator with other responsibilities and duties.
And are you assigned to any particular attorney in the Major Case Unit?
Right now, Clint Rucker.
And what is the Major Case Unit? Why don't you tell the jury what that is?
So all the homicides within Fulton County, which could be from North Fulton to South Fulton, we receive the cases from the lead detectives that investigated those particular homicides, and then we take those cases and we do and conduct independent investigations.
Now, when you say independent investigations, is the Fulton County District Attorney's Office an independent agency from the Atlanta Police Department or any other police departments within the jurisdiction of Fulton County?
Yes, that is correct.
Okay. And are there times that the two agencies here, Atlanta Police Department and the Fulton County District Attorney's Office, that they coordinate or work together in an investigation?
Yes, that happens.
And when doing that, does the police department have to follow any recommendations that the District Attorney's Office recommends?
They do not.
And if the Atlanta Police Department or any police agency was to recommend that the DA do something, does the District Attorney's Office, are they required or obligated to follow those recommendations?
Not required. No.
Now, can you tell the jury how you got involved with this case, the state of Georgia versus Claude McIver?
Yes, the initial lead investigator for this case was Investigator Terry Jackson. She left our agency and went to the DeKalb County District Attorney's Office. And then I was assigned to this case March the 31st of 2017.
And is that when you also became the deputy chief of the major case unit?
That's correct.
Now, in this case, through your investigation and, I guess, review of the documents, was there any coordination between the Atlanta Police Department and the District Attorney's Office?
Very little.
And is it common, based on your 20-plus years in law enforcement, that after the District Attorney's Office receives a case, that charges are enhanced, added, modified?
Yeah, let me object to that. The charges are the charges, and any commentary about charges and who makes decisions and how it's done is irrelevant and prejudicial.
Your Honor, I would respectfully disagree as to the relevance due to the fact from prior testimony from Investigator Smith, the defense, as well as the state elicited.
No, the defense did not.
Before we get too much back and forth, if you want to ask questions along this line of whether, because the police charge X, the DA's office is bound by that, I'll allow that. But as to the thought process behind what the right charge is or something like that, we need to stay away from that.
Yes, Your Honor, that wasn't my intention. My question was, is it common when a case comes in that charges change based upon the District Attorney's investigation?
Okay, I'll allow that.
So you can answer Investigator Griffin.
Yes, it is very common.
And did that occur in this case?
It did.
Same thing.
So let's stay away from specifics. The jury has heard what it calls from Detective Smith about what APD did. The jury has the indictment, and if during closing arguments folks want to talk about whether there were changes and whatnot, that's fine, but I don't think this is the right witness to explore that.
Yes, Judge. Now, when you initially started working on a case, can you tell the jury the first things that you did to begin your investigation?
Yes, I reviewed the formal report from Detective Darren Smith from the Atlanta Police Department. After that, I reviewed notes from Investigator Terry Jackson. I saw the tasks that she fulfilled.
And about how long did it take you to review the documents from the Atlanta Police Department as well as from the previous investigator on the case, Mr. Terry Jackson?
About 2 or 3 weeks.
Now, as part of your investigation, you referenced that Investigator Jackson takes notes. Do you also take detailed notes of the steps that you take throughout your investigation?
Yes, I just document what I've done and different tasks that I fulfilled.
And do you interview, or you take part in the interview of witnesses?
Yes.
And are those interviews audio or video recorded?
They are.
And if, in an instance where you don't have the ability to do that, do you take notes about those interviews?
Yes, I write summaries as to what that particular witness told me or what the interview was about.
Okay. Now, after you reviewed the documents that had occurred before you, what was the first thing you did in your initial part of the true investigation?
Yes, I began looking into the backgrounds of the defendant and Mrs. McIver, where they worked, family dynamics, who they were affiliated with. Then I started to proceed towards the elements of the crime that night.
And did many of the steps you took in your initial part of your investigation center around things not done by the Atlanta Police Department?
And again, let me object to that question. It's precisely what raised earlier.
I'm remembering what you raised earlier to be related, but a little different than that. I'll allow that question. My understanding was we weren't going to march through everything, and I'm not saying you've begun to do that, but if you want to repeat the question for the witness, I'll allow it.
Did many of the things that you did at the initial part of your investigation center around things not done by members of the Atlanta Police Department?
Yes, they did.
And did you request or subpoena documents related to the defendant as well as the victim?
I did.
And what kind of documents were you requesting or subpoenaing?
Financial documents and any other documents that would give me any more information about the defendant or Mrs. McIver, the victim.
Did you interview close friends of both the defendant as well as the victim?
Yes, I did.
As well as employees employed at both the defendant's place of employment and the victim's place of employment?
Yes, I did.
Did you have an opportunity to drive the route that was taken that evening?
I did. I did it about 3 times.
And did you also participate in the execution of search warrants?
I did.
Now, can you tell the jury how many search warrants that you participated in?
I completed 4.
Excuse me, the number of search warrants, how is that relevant to anything? And unless we're doing chain of custody, unless we're going someplace in particular, the judicial imprimatur of a search warrant, I think, is more prejudicial and probative at this particular point in a generic form.
Okay,
I can ask a different question.
I'm okay with that question as long as, per your representation, then you're not diving deep to say, let's talk about each one and everything that was recovered in each one, because that's not what I understood was going to be happening. If you wanted get an answer to how many were you involved in obtaining, I'm all right with that.
Yeah, thank you.
Okay.
So how many searches were you a part of?
4 search warrants.
And can you briefly tell the jury where those took place?
Yes, the first one was at the Harold Hudson Law Firm in Buckhead.
And again, Judge, just saying where a search warrant was executed, again, it puts a judicial imprimatur on it without anything in particular. You know, I did 500 search warrants. So what?
Well, I think that I'm not going to get into what the so what is, but based on our discussion this morning, I understand there to be a so what that I think makes the inquiry relevant at the high level that we're going through this. If we start to get specific, we'll need to revisit that. So you can continue. So the first search, Harold Hudson's office.
And I guess can you tell the jury why a search of Mr. Hudson's law firm occurred?
We were looking for
Stop.
Judge, why? I mean, can we come to sidebar?
Well, we can in a second if we need this. What I think is an appropriate question is, what were you looking for? Now, that is a version of why. I think that's relevant, and I'd allow that. If we need a sidebar to discuss why you shouldn't be able to ask what was the object of the search at location X, we can have that sidebar. I think that's relevant, and I think I would allow you to ask that as to the 4 searches that we've heard the investigator reference. If you want a sidebar on that, we can have that. If you want to preserve something and we can discuss it at a break, we can do that as well. I'm happy either way.
I think it's limited by you, what we were looking for. You're going to allow that. You just said you were.
Yes.
So I don't need an additional sidebar, but may I maintain my objection?
You may. It's preserved.
And just for your honor and defense counsel, the questions are merely just to explain what Investigator Griffin did to investigate the case.
I understand what you're doing. So if you want to ask as to each of those warrants merely what was the object we were looking for, that's okay. But we had a discussion, I think you were coming in and out of the courtroom while we were having it, before the jury came in, that explaining exactly what Investigator Griffin did each step of the way was represented to me by your colleague, that that's not what you'd be doing. There may be things you are highlighting, and so far I'm okay with where we're going. If it becomes too much of a laundry list, I indicated that I would revisit Mr. Harvey's concern about that.
And again, this is course of conduct, and this investigator's course of conduct is not an issue in this trial. And so I want to reiterate that that question was specifically course of conduct.
Well, I think Mr. Abate's explanation for one reason why he's asking it resonated more as course of conduct, but it was relayed to me before the jury got in here as to another reason as to why this is being explored, and I believe that continues to justify these questions for the time being.
Okay.
All right. So
instead of why, I'll ask a very similar question. What were you looking for?
A second will,
And how long did that search take?
about 3 hours.
And through your search of Mr. Hudson's office, were you able to locate a second will or a will subsequent from 2006 of Ms. Diana McIver?
I was not able to locate the second will.
Did you also, as part of that search, search Mr. Hudson's residence?
I did.
And at that residence, were you able to locate a subsequent will in 2006?
No.
Now you said you did 4 searches. Where did the second search occur?
The second search occurred at the Buckhead condo on Kingsborough Road. That's where the defendant and Ms. McIver resided, and that was on April the 14th, 2017.
And generally, before all the searches occurred, were videos or were the conditions of the areas documented prior to the search?
Yes.
And were photographs taken as well?
Yes, and video.
And during the search or how long did the search of the Buckhead condo take?
Approximately 4 hours.
And during that search, did you locate Ms. McIver's safe in her closet?
I did.
And were you able to gain access to it?
Yes.
And did you find a second will in that safe?
I did not.
And before you gained access in April 2017, did the defendant have access to it?
Yes.
Excuse me.
you might need to lay a little foundation before she could be doing something other than speculate.
Okay. I was trying to follow the streamlined approach versus the not ask a whole lot of questions about the searches. So
Life is a long and winding road.
so I will ask some more questions about the safe. Based on so you said you gained access to the safe.
Yes.
And prior to gaining access to the safe, had you interviewed witnesses concerning Mr. McIver's access to the safe at the Buckhead condo?
Yes, I did.
And when did those interviews occur before your search of the condo and the search of the safe in 2017?
Yes, they did.
And based on your investigation, was the defendant residing in the Buckhead condo prior to your search of the April 2017 search?
Yes, he was.
And was he living there immediately after the incident occurred on September 25th of 2016?
Yes.
And based on your investigation, did Mr. McIver have access to the safe prior to your searching it?
Same objection.
Don't answer the question.
Same objection. It's based upon.
Sure, sustained.
Now, from the search of the condo on Kingsborough, were any items of evidentiary value seized?
And can I object to the to the question, any items of evidentiary value?
I'll rephrase the question. Was anything seized from the Buckhead condo?
Yes.
Question, okay. So sustained, and I'll rephrase the question.
Yes.
Okay. And what was seized generally from the Buckhead condo?
Can I speak with Mr. Bunch?
Sure. From that search, what was seized from the condo?
Numerous boxes, banker boxes filled with documents, financial documents, and other documents related to the scope of our search is what we thought at the time.
And do you remember about how many?
About 20 to 25 boxes.
And when the search was completed, was the condo in the same condition as it was found generally?
It was.
And what was the next search you participated in?
Yes, well, at the condo also, with the boxes that we seized, we also seized some digital media as well. I forgot to mention that. Apple iPad and a hard drive and a computer. And that concluded that search for the condo.
And the subsequent search was where?
Yes, at the Putnam County Ranch in Eatonton, Georgia. And that occurred on April 19, 2017.
And did you follow the same procedures that you described to the jury with that search?
I did.
Was anything seized from the Putnam County Ranch?
Was not.
And were pictures taken?
There were.
Did you also search a storage unit here in DeKalb County?
I did the same date as the condo, April the 14th. It was the public storage in Brookhaven. And it was where Mrs. McIver and her business partner with DRS Investment shared the storage unit.
And from that search, did you seize anything?
Yes, we seized 2 banker boxes from that location.
And after you seized the items from the searches that you just described for the jury, where did you place those items?
They were securely placed in our evidence room here at the Fulton County District Attorney's Office.
And were those items that you described, the documents as well as the hard drives and other electronic devices, were they reviewed by an independent team of lawyers?
They were.
And can you tell the jury why?
To ensure that we did not receive any privileged information or attorney-client privileged information, only documents that pertain to the scope of the search that was indicated in my search warrant. So that team served that purpose.
And did the team of lawyers review all the documents and the items that were received during those searches?
They did.
And was a second will located from the review of those documents?
No, it was not.
Now, I know you said that you had interviewed several individuals from the Tory company. Did you investigate about events that occurred when Mr. Macgyver came to the establishment on September 22nd of 2016?
I did.
And from those interviews, who did you interview?
I interviewed Gail Meadows, Elaine Williams. They were administrators there. I also interviewed Jay Grover, Ken Ricker, Angie Brooks, and I also interviewed Billy Corey himself and 2 other former employees of the Corey U.S. Enterprise, which was Ms. Johnna Griffin and Rachel Stiles.
And from the interviews, did the individuals who saw Mr. Macgyver on the 22nd describe his demeanor or conduct? Now tell me what they said after they described the demeanor or conduct.
Yes, they described it to me.
Now, to your knowledge, had anyone from the Atlanta Police Department spoken to members of the Corey company about those events on the 22nd?
Once again, that would help with your search as well.
Okay. Now, you talked about your visit to the ranch in Putnam County for the execution of a search warrant, did you make any additional trips to the Putnam County Ranch?
Yes, I went to Putnam County and I went to the ranch about 3 times as well.
And did you speak to individuals who came in contact with the defendant and Ms. McIver throughout the weekend, beginning on the evening of September 23rd of 2016 to September 25th of 2016?
Yes, I did.
And did you speak to Tanner McKinney and Miss Samantha Watson?
Yes, I did.
And did Mr. McKinney describe to you any interaction he had with the defendant?
And at the end that calls for, I hear some response, even if it's just yes or no.
I can rephrase the question.
Okay.
For the interviews that you did with Samantha and Mr. Tanner, were they audio recorded?
Yes, they were.
Okay. And were they at the ranch on Sunday, September 25th of 2016?
Same objection. We heard from them.
I understand that we did.
Sorry. Got that, same objection.
All right, I understand the objection.
And I can move on. I also understand the objection.
Okay,
So,
great. We'll move on.
did you have the opportunity to also interview Mr. Craig Stringer?
Yes, I did.
Okay. And as well as Miss Danny Jo Carter?
Yes.
And did you have an opportunity to visit the golf courses at Reynolds Plantation?
I did not. I did assign another investigator to go to Reynolds Plantation.
And based on your investigation on September 25th of 2016, where did I'll ask a better question. Did you have an opportunity to go to the Longhorns in Congress?
Yes.
And did you speak with Jonathan Moore and Isabel Williamson?
Yes, I did.
Williamson, excuse me. Okay. And through your review of the documents from APD as well as from Investigator Terry Jackson, did you see a receipt from the Longhorns misconduct from that night?
Yes.
And based on your review of that document and your investigation and interviews with Ms. Williams as well as Mr. Moore, about approximately what time, or were you able to determine the time that the McIvers and Ms. Danny Jo Carter left the Longhorns location?
Yeah, same objection.
If you want to key it off the receipt, which is something in evidence, we can do that.
Have we received the evidence?
The evidence is here. I can't promise you that it's in numerical order or anything, but it is in several boxes right now.
How we move on and come back to it.
Okay.
Now, do you know how the defendant and Danny Jo Carter and Ms. McIver left, or what they were traveling on that evening?
Yes.
Again, everything the investigator knows comes from somebody else. So if anything she knows is per se hearsay.
I'll ask 4 other questions to get to where I'm trying.
Okay. I don't think that it's fair to say everything, but much.
No, I agree, and that was a little bit overstated, and I apologize. If you tell
Did you have the opportunity to view or examine the 2013 Ford Ranch expedition?
Yes, I did.
Or King Ranch expedition, yes?
Yes.
And where is that located today?
Yes, it is also in our evidence facility secured with the Fulton County District Attorney's Office.
And has it been in that location since the District Attorney's receipt of it?
Yes, since we received it.
Now, you said you traveled the route that was taken on September 25th several times?
Yes, about 3.
And as a law enforcement officer for 10 years prior to being with the District Attorney's Office, did you have any experience or have the opportunity to go to the Edgewood area?
Yes.
And how long have you, or where do you live? What area do you live in?
South.
Okay. And through your living in South Fulton, close to the city of Atlanta, have you also had any familiarity with the Edgewood exit and area?
I have.
Okay. And in those, I guess, times that you have been in that area, have you seen a large amount of homeless people under the underpass?
Yeah, let me object to that. As relevant. And her experience is essentially her opinion. Her opinion is irrelevant and more prejudicial than probative, and under the same circumstances, not under the same circumstances as the circumstances here. So I'm objecting to that. I will object to that question.
You have objected to it. I think it's a fair objection. If you want to explore further with this witness as to whether she could discuss that area in a way that's more germane to this case, I'll let you do that.
Okay. Through your, I guess, experience of being in that area, have you been down there at night?
I have.
Okay. And have you been in the area of the underpass in the evening?
I have.
Okay. After 10 o'clock?
Yes.
Okay. And in those times, in the times that you also drove the route, were any of those times in the evening?
Yes.
And through your prior experience with the Edgewood underpass, as well as the times that you drove the route in the evening, did you see a large amount of homeless people?
Same objection. I don't think it is an appropriate subject that this officer's personal experience on an unknown number of occasions at an unknown time at an unknown date is relevant testimony to the night of September 25th, 2006.
No, overruled. She can answer the question.
No, I have not.
Now, also, as part of your investigation, did you speak to homeowners and business owners in that area?
I did not, but I did assign an investigator to go out for that purpose in that area.
Now, do you remember when the District Attorney's Office received the King Ranch expedition?
Yes, it was February I'm not sure the actual date, but it was in 2017.
And how many times would you say that you have had an opportunity to view or examine that vehicle?
About 7 times.
And in the times that you have done that, were you able to determine if the vehicle had a navigation system?
Yes.
And were you able to determine if the vehicle had Bluetooth capability?
Yes, I was.
Okay. And did you actually turn the car on?
I did.
And did you test the navigation system?
I did.
And when you had the car on, were you able to determine if a cell phone or telephone had ever been paired with the Bluetooth in the vehicle?
Yes.
And who did that vehicle belong to?
The vehicle was registered to the defendant, Lee McIver, III.
Now, as part of the times that you viewed or examined the vehicle, was anybody with you?
Yes, on different occasions.
And were you present when Michael Knox or Carl Rohn looked at the vehicle?
Yes.
Okay. And who is Carl Rohn?
He is a firearms expert.
And did he examine the SUV?
Yes, he did.
And did he cut into an area of the front seat as part of his examination?
Are we talking about Rome? Can I come to sidebar?
Sure. Were we blinding you guys again? Sorry about that. In the trial last week, they must not have cared about their jurors in the same. I don't know how they did it. They finished that trial in 1 week or two. Just saying. Okay, you were asking a question about Mr. Rohn. You wanted, just so we close the loop, I don't know.
Yes.
There was the objection.
I believe the question was, did Mr. Rohn cut into a small area of the front seat?
He did the front passenger seat, yes.
And did it all alter the route or the track of the projectile?
Well, wait. Unless we have some expertise in that.
Yeah, so that one,
That's a different question. Did it cut into the bullet hole in the front seat?
It did not. It was
And did Mr. Knox, did he do the same examinations that Mr. Rohn did?
He did.
And why did Mr. Knox do that?
Okay, again, Mr. Knox testified, and Mr. Knox can testify about why he did or why he didn't do something. I think object to the question.
I gather.
I'll ask a different question.
Okay.
Why did the district attorney's office ask Mr. Knox to do examinations that Carl Rohn had already done?
Same objection. Same objection.
How is it relevant to what the jury's working through that your office may have had two different people do some work on the car?
I guess it's not.
Okay. The next question.
Well, can we approach Your Honor for a quick second?
Sure.
Now, Investigator Griffin, did you also have an opportunity to interview individuals from Emory University?
Yes, I did.
Did you interview a large number of personnel from Emory University?
Yes, I did.
And do you remember how many people you had interviewed from Emory University?
I think it was 27.
Okay. And you said you received Detective Smith's report?
I did.
And how many people did he interview from Emory University?
I saw one with Dr. Hardy, Susan Hardy.
And you interviewed 27?
Yes, sir.
Did you have an opportunity to interview a Dr. Salim Shagler?
I did.
Okay. And was that interview that you did part in, was it audio recorded?
Yes.
Okay. And through or during that interview, do you recall Dr. Shagler saying that the defendant had told her that the victim, Ms. Macgyver, was holding the gun when it went off?
Yes, I do.
Now, in addition to the report that you received from Detective Smith, did you also receive any audio or video recordings that he did?
I did.
You did? And from those audio recordings, did you have one from Miss Gail Meadows or Miss Elaine Williams?
No.
Now, through your time, or I guess the several times that you drove the route, was on that route the intersections of 12th and Piedmont and 14th and Piedmont Road?
Yes.
And are both of those locations located within Fulton County?
Both of them are.
Also, as part of your investigation, did you did you interview Miss Wendy Edson?
Yes, I did.
Okay. Did you physically go down to her funeral home in Congress, Georgia?
Yes, it was Phoenix Crematory.
And did she provide you with documents that correlated with Ms. McIver's cremation?
Yes, she did.
And if any of the individuals that you spoke to, were they able to provide you with the subsequent or second will of Ms. Diane McIver?
They were not.
And through your review of all of the documents that you participated in the seizure of throughout the search warrants and throughout your entire investigation, were you able to locate a second will?
I was not.
Did you also have the opportunity to go through the hard drive of Diane McIver's computer?
Yes.
And where was that computer located prior to the district attorney's receipt of it?
It was at U.S. Enterprises, the Corey Group.
And did you go through, was that sent to the GBI?
It was.
And was it examined or imaged by Ms. Lisa Arnold?
Yes, it was.
And did you receive the imaging of the hard drive from Ms. Lisa Arnold?
Yes.
And did you go through each and every document from Mrs. McIver's hard drive?
Yes, with much needed help, but yes.
And from Mrs. McIver's hard drive, were you able to obtain or did you find any documents related to her financial standing?
Yes.
Again, that would be called for a hearsay response. Have to look at the documents, make a determination about what they are, and then.
Right now, I'm just working through, we also have some business records, but those would have come through a different source than the hard drive, so I agree.
And with all due respect to the defense counsel, I believe the hard drive was admitted into evidence through a stipulation about what the procedures that Ms. Lisa Arnold took.
Yes, but that does not answer the question. Yeah, it was just authenticated.
I mean, there may be items on there that you want to use if the right foundation has been. I'm not disagreeing with your representation of what happened through the Lisa Arnold stipulation and evidence being admitted. That may be exactly right. But I guess you need to, that there may be some things on there that you want to use. I don't know.
Right. Were there items on the hard drive that dealt with numbers?
Yes.
Numbers? Is that the question?
That's the question, that dealt with numbers.
And how did you?
Same objection. I reckon, whether it's letters or numbers.
Symbols?
Symbols.
Did you also, from the examination of Mrs. McIver's computer, look into her emails?
Yes.
And were there a lot of emails?
A lot.
And the vehicle that you said was stored in the district attorney's facility, is that vehicle available for the jury's view.
Yes, it is.
No further questions, Senator.
Mr. Harvey, do you have any questions for Ms. Investigator Griffin?
Before Mr. Harvey does that, can I ask one additional question?
You may, because he was thinking, we'll give him a little more time. The end is near for direct examination, so.
I know, I'm still thinking.
Okay.
I'm a slow thinker.
And Ms. Griffin, through your employment with the District Attorney's Office, do you interact with the District Attorney, Mr. Paul Howard?
Yes.
And what kind of phone does Mr. Howard use or have? Cell phone?
He has an iPhone 6.
And how long has he had that iPhone?
Maybe about,
Based on your personal observations, keep going before defense counsel objects.
yes,
That was close.
about 2 years, maybe, almost 2 years.
No further questions at this time.
All right. Mr. Harvey, do you have any questions for Investigator Griffin?
Yes.
Okay.
Good morning, Ms. Griffin. How are you?
Good morning, Mr. Harvey.
Smiling. You're smiling. Good. I understand that you came on board in this investigation at the end of March in 2017, correct?
Yes, sir.
At the time that you had come on board, a couple of things had, in fact, been done in the investigation, correct?
That's correct.
The vehicle that you have described to us had been processed by the APD crime scene unit, correct?
Correct.
So if there is a crime scene and the vehicle itself is that crime scene, then that had already been photographed, processed, measured, so whatever measurements were taken in September of 2016, correct?
Correct.
Then the vehicle had been released, correct?
That's correct.
It had been released back to Mr. Macgyver.
Yes.
Subsequently, the Fulton County District Attorney's Office got a court order to keep the vehicle, correct?
Correct.
And that vehicle was returned in October of 2016, correct?
I'm not sure if I'm following you.
You know ADA Mike Sprinkle, correct?
Yes, I do.
Right. And you know that the expedition was returned on October 7th of 2016 when James Hughes returned it, correct?
I'm familiar.
And Mr. Sprinkle got a court order.
I mean, with your question, can you
Okay.
ask it again?
You understand that on October 7th, Mr. James Hughes returned the expedition to the Fulton County District Attorney's Office.
I'm with you now.
Okay. And then in October of 2016, ADA Mike Sprinkle, who we've seen on the witness stand, got an order, a court order to hold the vehicle. So that was done back in October of 2016, right?
Okay. Yes.
Okay. So one thing that was done, the vehicle was processed, the vehicle was seized, you had the vehicle as of October of 2016, correct?
That's what I'm unsure about. I know in February the 2017 date is when we received it back to hold, to keep.
Okay. Well, then James Hughes turned it into whom? On October 7th of 2016, because that's what Darren Smith testified to.
I would have to look at what you're speaking
Call
of.
for speculation as well as hearsay.
Okay, so you don't know whether or not it was turned in on October 7th of 2016, correct?
Not to us, the Fulton County DA's office.
You don't know whether that was done on October 7th of 2016. Okay, and you don't know whether or not the Fulton County District Attorney's Office got a court order on October 28th of 2016 to keep the vehicle?
I can't recall that right now.
Okay, you just don't know. That's the vehicle. You also know that the weapon that was involved was seized immediately in September of 2016, correct?
Yes, I did see that.
And that weapon was sent to the crime lab, correct?
Yes, it was.
In 2016,
Yes.
correct? And it was examined in 2016, correct?
Yes, it was.
Okay. So the crime scene, being the vehicle, had been processed, turned over. The weapon had been processed and turned over. The documents at Corey, you're familiar with the documents that were taken from Corey, correct?
Some of them, yes.
Yes. Some of them?
Right, I mean, at what date are you referring to specifically?
They were gathered by people at Corey, correct? They were taken out of a locked file cabinet, correct?
Okay, yes, I'm familiar with that.
And they were gathered by the people at Corey who went through those documents, put them in boxes for pickup, correct?
Yes, that's correct.
So all the documents at Corey had been gathered by Corey personnel.
I'm going to object, same objection, that's what happened, I mean, correct, this is all calls for hearsay.
Okay.
Well, if we're talking about course of conduct, which you allowed over my objection, then I am entitled to go into what was testified to on direct examination.
You are, without getting into hearsay areas.
Okay. Did you gather those documents and review those documents? The documents that came from the file cabinet at Corey?
To my understanding, those documents were given to the defendant.
Okay, and were they retrieved?
I have not seen those unless those were some of the ones that was in the search warrant that I conducted on April.
In the condo?
In the condo, yes.
Okay.
So I wouldn't know if those were the same documents that were given him that was before me.
And you also got some, the state, I mean you, got some documents from the people at Corey prior to your entry into the case. Those documents you reviewed as well, correct?
I'm familiar.
Okay. One of the documents that was produced from Corey was a 2006 will, correct?
Okay, yes.
Okay. And that's the will that was offered for probate, correct?
Correct.
All right. Processed the car, investigated the gun. A 2006 will was offered for probate, correct?
Correct.
And through 4 search warrants, review of any documents provided to the state, it is my understanding that throughout all this investigation, there has never been recovered a second will, correct?
That's correct. Only testimony.
Okay. I think that's all I have. Thank you.
Mr. Abate, any redirect?
Yes, Mr. Fairbury. Mr. Harvey on Cross was asking about the gun that was recovered in process.
He did.
And have you had an opportunity to look at, hold that gun?
Yes, I have.
And did you do any investigation about the firearm that was located inside the SUV?
Well, I don't know what that question means. Any investigation, I think it's pretty broad.
If there's a document you want to share with Mr. Harvey,
While Mr. Howard looks at that, I'll ask you some questions. Do firearms have serial numbers?
They do?
And can those serial numbers be traced?
Yes, they can.
And did you trace the serial number on the firearm that was located in the vehicle?
Yes, I did.
And did you have an opportunity to watch the interview that was done with the defendant at APD?
Yes, I
And
did.
do you recall where the defendant said he got the firearm that was used to shoot Mrs. McIver?
Yeah, how is this? Correct.
Why
I
did he
didn't
ask?
ask about the provenance of the weapon. I said the weapon was recovered and it was processed by the crime lab.
And I would say that this is also part of the processing of the firearm that was located in the vehicle.
Okay, I think what happened with the firearm was explored by both sides. You can continue to explore it.
And do you remember watching that interview?
I do.
And do you remember where Mr. McIver said that he got the
But
purchase?
not in this context. Not with commentary about what may or may not have been said by someone in another interview.
I think if you want to work through the document in your hand, you can do that. The doc you're trying to connect now would be appropriate in a different setting, like a closing argument or something.
Okay. And my only response to the defense counsel would be, during his cross-examination, he asked about all the things that she reviewed that APD as well as her predecessor had done. So this is part of her review of,
But the interview says what it says, so I think the objection I think I'm sustaining is a question that says, do you remember where in the interview X was said? I don't think that ties in so much with the cross, but what you have in your hand is what I think it is. You can continue to explore.
I'm going to show you what the market states is at 510 Investigator Griffin. Do you recognize that document?
Yes, I do.
And what is stated at 510?
It is a firearms trace from the ATF, alcohol, tobacco, and firearms unit, and they traced the weapon.
Yeah, but then about the content.
And
Not the content, what it is,
Right.
not the content.
Don't go, it's just, she said what it was, it's a trace on the weapon, period.
And does that document, the trace, the ATF trace on the weapon, appear to be a fair and accurate copy of the trace that you received after you ran the serial numbers for Mr. McIver's weapon?
Yes.
At this time, Your Honor, the state would tender what the market states at 510 evidence.
You know, I've got an objection to the document because it hasn't been authenticated in any shape, form, or fashion other than it's something she received from somewhere. So I do have an objection to the document. A foundation hasn't been laid, nor has it been authenticated.
I can definitely ask additional questions to lay the foundation from which Investigator Griffin said she received the document from ATF.
You can ask some more questions. Tell me the authentication things.
Well, it's, first place, it's Classic 801. And unless it is properly authenticated under perhaps some other 8 series exception, then it is not admissible because it's 801. Yeah.
No, I understand what you're saying. I'm just trying to work through if a vehicle, someone had a vehicle registration, something where it's the product of a database, etc. But this is in connection with an investigation that it was prepared, so it's not. I guess you can ask some more questions, and we'll see where you get with it.
Okay. Now, Investigator Griffin, can you explain to the jury what you do with the serial number from the weapon? Who do you send it to?
Yes, you submit a request to the ATF, which is alcohol, tobacco, and firearms unit, with the pertinent information from the weapon that you're researching, and then they give you results for that.
And why do you send that request to ATF? What do they do?
Yes, they trace the actual weapon to see.
And again, I don't know whether this witness knows what the ATF does.
What is ATF, or what is the ATF?
She said several times, alcohol, tobacco, and firearms.
What I thought too. But
Okay.
what does that agency do?
Yes, they,
I'm sorry, but this witness hasn't been qualified to testify about what the ATF does, how they do it. Whatever they may do is something out of court, offered for the truth of the matter asserted.
Okay, I agree.
Have you ever run an ATF search before?
yes,
How many times?
numerous.
Did you run ATF searches while working at the Fulton County Police Department?
Yes, I did.
Have you run ATF searches through your 10 years here at the Fulton County District Attorney's Office?
Yes, I have.
How many would you say?
Maybe about 20.
And when you have done those searches, did you receive a document similar to the one you were holding, State's Exhibit 510?
Yes,
Did you follow that same procedure when you ran the serial numbers for the weapon located inside the King Ranch expedition?
yes, I did.
And is State's Exhibit 510 a fair and accurate copy of the document you received from ATF after providing them with the serial numbers from the weapon that was found in the expedition?
Yes.
Same objection.
So here's where we are. You have, I think, Mr. Abate, done a great job of having the witness describe that effectively there's this box that spits out these reports and you put in a serial number. You are seeking to offer what's on that report as the truth of the matter asserted there. This gun belongs to X, according to not this person, but whoever is hiding inside that box generating the reports. I think absent some other certification or testimony, the hearsay objection remains a valid one. I don't know that what we're getting at is hugely in controversy, but that doesn't make the objection less valid.
Yes.
So you may want to explore this with a different witness at a different time, but I think you've hit a dead end with this witness.
Yes, Judge, and we can call an additional witness.
Any other questions for Investigator Griffin?
One last question, Investigator Griffin. What kind of information are you requesting when you make a request with the agency, ATF?
Ownership and registration information to that particular weapon.
I'm sorry, I missed that.
Can you just repeat that right into the microphone?
Ownership and registration information to that particular weapon.
Nothing further.
I have one question to follow up on that.
Okay.
If the information on the ATF report might include the purchaser, correct?
That's correct as well.
As opposed to any current owner, because any current owner or person who might have possession of that gun could have been legally transferred from the purchaser, correct?
Correct.
Thank you.
Jurors, if you have any questions for Investigator Griffin, if you would pass them to your left and down, Deputy Murphy will collect those. We'll see where we go. I think after that, we'll take our morning break. Thank you. Do you know why the SUV was returned to Mr. Macgyver or someone by the district attorney's office once and then reclaimed again? And if you, the question is, do you know? Let me ask that better. Why was it returned the first time?
I knew that there were additional testings that we wanted to perform on the actual vehicle with different experts.
Any follow-up based on that?
Who returned the vehicle the first time, if you know?
I do know that Detective Darren Smith with the Atlanta Police Department.
You returned it to the DA's office.
I'm sorry?
You returned it to the DA's office?
He returned it back to the defendant.
And who gave it to the DA's office?
Yes, it was through James Hugh and Detective Darren Smith. That's how we obtained the vehicle again.
And you talked about additional testing. Was the reason that additional testing needed to be done was because it wasn't done in the initial processing by the Atlanta Police Department?
The objection to that question.
The testing that you talked about, had that been done by the Atlanta Police Department?
That had not been done.
Mr. Harvey, any follow-up?
Sure. I'm sorry, but the testing that you had done by Mr. Knox and Mr. Rohn that you told us about, that wasn't until October of 2017, is that correct?
That's correct, and it was held in February 2017.
The order was signed in October of 2016 and it was returned in 2016, but the testing that you're talking about didn't occur until October of 2017, is that correct?
That's correct.
Okay. And that was by people that were paid by the district attorney's office, correct?
But they were employed as experts, so yes.
Yeah, okay, well, they were paid, right?
Yes.
Okay. And Mr. Knox got how much?
I don't know.
Okay, how about Mr. Rohn?
I don't know.
That's all, thank you.
All right. Thank you, Investigator Griffin.
Thank you, sir.
You can step down. Ladies and gentlemen, we're going to take our morning break. Lunch break is going to be just before 12:30 for your planning purposes. You recall the routine, and if you don't, I'll remind you. During the breaks, whether it's for lunch or whatnot, you guys are free to chat, do what you want. Just don't talk about the case, no outside research, anything like that. We'll get you back in here in about 10 minutes. I know there's at least one matter that we need to take up outside your presence, so the break may run a little bit longer, but it wasn't something we could do before we pulled you in here this morning. All right, thank you, Deputy Murphy.
All rise for the jurors.
Who's your next witness? Okay, well, why don't we take the break first? And then when we get everyone back here in 5 to 6 minutes, is the folks who need to be back here, we'll get Dr. Sellers on the stand outside the presence of the jury to cover what we need to cover. And then assuming he's going to be permitted to testify, the jurors can come on in with Dr. Sellers here. If the finding is otherwise, then whoever is after Dr. Sellers, we can bring on in.
Right, and I'm also going to approach with the signed stipulation only because I'm going to ask it published probably sometime soon when they get back.
Okay. We had a couple of sidebars that related to Carl Rohn. Mr. Harvey had a couple concerns because Mr. Rohn hadn't been called to testify, and Mr. Harvey was under the impression Mr. Rohn would not be called to testify. And there were some references to steps Mr. Rohn took that weren't reflected in the video that Mr. Harvey had. Mr. Latte assured Mr. Harvey that there was additional information from Rohn or from the DA's office about what Rohn did, in particular cutting into a seat that had been provided to the defense. We didn't really need to resolve that because my understanding of the discussion with the attorneys is that there wasn't going to be more with Mr. Rohn than what we heard, and people went back to their tables content enough with that. Mr. Harvey, anything more you want to get on the record concerning the two Rohn sidebars?
No, sir, thank you.
Mr. Latte?
No, Your Honor.
Okay, anything from the defense before we break?
No, sir.
Then we need Mr. Macgyver and whatever attorney is going to be wanting to ask Dr. Sellers questions about what he knows about the case and how he learned about it in about 5 or 6 minutes. Thanks.